Dear participants, a very warm welcome to this lunch webinar. As President of the European Law Institute, it is my great pleasure to welcome you all to this webinar on ELI Guiding Principles and Model Rules on Digital Assistance for Consumer Contracts. These ELI model rules have been approved by the ELI Council on 3rd March 25 and by the ELI membership on 15 April 25, and they have just been published on the 19th of May 2025. As these guiding principles and model rules are so important, we have decided to organize two webinars. This first one will therefore cover general framework and design requirement, and we will have a second webinar which will take place on the 24th of June, again from 12:30 to 2 p.m., dedicated to more specifically the algorithmic contract. Christoph Busch, Teresa Rodriguez de las Heras Bayel, Marie-Jules Sorensen, Darius Sojek until October 23, and Christian Twig-Flessner were all co-reporters, and Christian Twig-Flessner was also the one called the person with the file, the one ensuring that everything stays in the file and goes forward. So thank you very much already, Christian, for that work, but also to all 4, 5, and 4 reporters for their tremendous job on these guiding principles. As for all ELI projects, the work has been also scrutinized, assessed, and influenced by many actors within the ELI Council members and the Executive Committee, the Scientific Director, Professor Christiane Wenderhorst, the various advisors and assessors, as well as various stakeholders who also took position on these guiding principles. Therefore, it is really the outcome of a very large assessment process, as for all other ELI projects, which ensures that the outcome is also in line with what is required for practical purposes. As you will probably hear later, there are several rules which have been published by other international organizations as well, in order to guide states in resolving the difficult question on what the legal consequences of these contracts are, and in the first place, of course, whether such contract concluded automatically via algorithm are or not valid. I'm happy that the ELI can now share and widespread these new standards, these new guiding principles that will be presented to you today and on the 24th of June. We have today a wonderful panel. I will, of course, present them as we will go along, but let me first mention that the Q&A function, as always, is available for you to ask in writing any question you want to ask to all the panelists, and don't wait the end, you can do it on the process, but we will answer these questions at the end, orally, at the end of the first round of short presentations. Let us now start with a presentation of ELI Digital Assistant for Consumer Contract Model Rules, with a focus on general framework and design requirement. This presentation will be done by Professor Christian Twig-Flessner. He is currently a professor of contract and consumer law at the University of Warwick. He holds a PhD from the University of Sheffield. He's a managing editor of the Journal of Consumer Policy. His research and teaching interests cover contract, consumer, and commercial law, particularly the impact of digitalization on these areas. Next to this position as co-reporters for the ELI model rules on digital assistant, he has also authored an ELI innovative paper on product liability reform, and is a past council member of the ELI. Christian, I'm really happy that you are with us today, and I give over to you.
Thank you very much indeed, Pascal. It is my great pleasure to be here this lunchtime and to share the work we've been doing for just over 3 years now for the European Law Institute, which has resulted in the ELI Guiding Principles and Model Rules on Digital Assistance for Consumer Contracts. I will say a bit more about the background in a moment and then present a brief overview and go into some detail on a few points. Let me just say a couple of things from the outset. Pascal has already mentioned that there are a number of other initiatives on algorithmic contracting in the field. And whilst our project originally started out much more broadly in its scope, thinking about algorithmic contracts generally, there was already fairly rapidly progressing work at ANSI trial, which resulted in the ANSI trial model law on automated contracting. And so we decided that Eli can make its most valuable contribution by focusing specifically on consumer contracts. And I will say a little bit more about why we are talking about digital assistance for consumer contracts in a moment, but this is what we have ended up with. I would also like to stress now that our guiding principles and model rules, even though they are developed under the auspices of the European Law Institute, are not limited to the European Union in their targeted readership or the kinds of people we want to reach with these. Of course, the EU is important, and Simona will give us her views on where we are at from the EU perspective in a moment. But these are also of interest well beyond the EU and indeed Europe, and we hope they will find a wide readership much more around the globe than just the EU. Now, let me start by talking about the idea that we are pursuing in the guiding principles. We've used the idea of a digital assistant as our focal point. Now, a digital assistant is our shorthand for a kind of application which relies on digital technology, algorithmic technology, probably AI-driven, but it doesn't need to be AI-driven in the sense of adaptive algorithms that can be used by consumers to automate some or all of their tasks in their contracting activities. We have envisaged these digital assistants to be perhaps a freestanding application that a consumer has on their phone, or perhaps something that's integrated into a smart product, such as our wonderful, much referred to smart fridge, or something else. And we also expect these digital assistants to have varying degrees of capabilities as the technology develops. We were very conscious of the fact that there's still a lot of uncertainty about the potential and capabilities of current technologies, but there's certainly a lot of interest now in the development of what are more generally called AI agents or electronic agents, Castobots, whatever you'd like to call them. So we felt this was the right time to really come up with some very focused consumer law rules for this process of automating transactions through a digital process. You can see on the slide there, we can envisage these things to be deployed in a wide variety of ways, whether it is to simply automate the reordering of a particular item from one supplier, for example, reordering your printer cartridges from the printer manufacturer, or reordering coffee pods from a coffee machine maker. Or you let the digital assistant find the best supplier for the item you're after. But at the most extreme, and this is the paradigm case we've worked with in developing our rules, at the most extreme, we have a digital assistant that can do a lot of contracting for a consumer. For example, do their weekly groceries, depending on the consumer's profile, on other relevant data, such as, I don't know, the weather perhaps, or whether the consumer is on holiday or at work, something like that. It can also perhaps choose a whole range of different suppliers, and it can just act in the background to help consumers. Whether consumers want to go that far is, of course, another question, but this is not our concern. Our concern was, well, what if we have a device like this? What would be the consumer law issues that would need to be addressed that are not currently addressed sufficiently? Our work builds on the guiding principles for automated decision making, which were authored, in fact, by my co-reporter Teresa Rodriguez de las Heras by Yale. We first produced an interim report in December 2023, which did focus specifically on the EU consumer acquis, where we developed earlier versions of our key guiding principles, and we also critiqued the acquis in its current state and recommended instances where improvements could be made. And following this interim report, we decided that consumer law and consumer contracting is where our focus should be, and this has now resulted in our wonderful guiding principles and model rules on digital assistance for consumer contracts. These guiding principles that we have, in fact, 8 of those, and it's worth just running through them very, very quickly because they give you a steer of what the substantive rules of the model rules look like. So our first principle is quite an important one, but one that's consistent with initiatives elsewhere. Actions of a digital assistant are attributed to the person using it. Because of the attribution effect, we are basically saying that where there is a contract concluded through a digital assistant, consumer law applies, pre-contract information obligations applies. We don't envisage a change in the scope of consumer law as to whether a digital assistant is used by a consumer or not. We also want to encourage the development of the use of digital assistants if they become available and they are sufficiently reliable. So we are basically saying that there should be no barriers to the use of digital assistants. If consumers would like to use them, they should be able to do so unless there are good reasons, legitimate reasons for preventing them from doing so in certain instances. For example, the bots that have been buying concert tickets, a big story everywhere, I think, they might still be disallowed. But also, it should be absolutely clear that any transactions arranged through a digital assistant are legally effective. There has to be transparency about the use of digital assistants, and we think this can probably be done by a technical process. I'll say a little bit more about this in a moment. And crucially, digital assistants, like consumers, must also be protected from manipulation. We all know that it is possible to already manipulate current AI systems, for example, through appropriately worded prompts. Prompt injections, prompt engineering is a big issue, and we do know that there is a potential for manipulating the outputs, and that needs to be controlled to ensure that digital assistants are not manipulated. One of the most important principles, so that's reflected throughout our model rules, is the fact that despite the automation benefits that digital assistants will bring, consumers must remain in control. And these controls have to be ex ante before they deploy the digital assistant, but also as the assistant is deployed. So if they, for example, wish to review contracts before they become legally effective, there has to be a process for doing that. If they wish to object to the conclusion of a contract, to have some control over the automation process, again, there has to be a mechanism for that. And of course, ultimately, consumers must be able to switch the whole thing off if they don't like it. Finally, if there are conflicts of interest arising through the use of a digital assistant, as a minimum, these need to be disclosed before the consumer commits to using a digital assistant, or afterwards, in which case the consumer must have the ability to step away from their digital assistant. In addition to these 8 express guiding principles, which were already developed in the interim report, we also have 2 disguised principles, which are kind of woven through the model rules. First of all, by saying, following with having a basic attribution principle, of course, we are saying effectively digital assistants are no more than a digital tool used by consumers. That is how we characterize them, and we do make this clear in the comments to our various model rules. And also permeating throughout our model rules is the idea that all the risks associated with digital assistants must be allocated appropriately between all the parties involved in such transactions. So there's a risk allocation dimension to what we've done. And again, this is explored more fully in the explanatory notes to our model rules. Very briefly then, what do we have? We have a focus on 2 different contracts, but these 2 contracts, the contract for the supply of a digital assistant, which is the contract under which the consumer actually acquires their digital assistant, and this is very much a contract for the supply of digital content or of software or similar. That is one contract. The second contract that we are focusing on in our model rules is the contract concluded through the use of the digital assistant, where the digital assistant has gone away, has effectively brought about a contract. That contract concluded through the use of the digital assistant is what we call the algorithmic contract. Now, the detail of these two of the provisions on these 2 contracts will be covered in the second webinar. So I won't say much more about this, but of course, it's important to bear this approach in mind. It's a 2-contract approach. We are focusing on both the role of the supplier or provider of the digital assistant, the role of the parties with whom the consumer would end up in a contracting relationship, and of course, what are the demands we make of the digital assistant itself. Now, there are 3 broad elements to our model rules in particular. We have a whole set of design requirements for digital assistants, more on which in a moment. Then we have our rules for the contracts for the supply of a digital assistant, and then we have rules on the algorithmic contract. Now, the design requirements are a really important feature because we thought about how best to ensure a good level of consumer protection where digital assistants are deployed. And our conclusion was that we couldn't just do this for traditional private law rules, which effectively rely on consumers to enforce those rules after the event, ex post. Yes, of course, we have public enforcement and so on, but we felt this was too late in the process and there was too much of a risk of consumer harm, consumer detriment. We felt that these devices, these applications, should meet certain essential criteria before they are deployed. Many of these will probably be designed and built in already as a matter of business decision, but we felt we wanted to give clear guidance on what we think we need to make these principles work, to make to sort of attain our objective of ensuring consumer protection. The first one is that the consumer must have control over the parameters by which the digital assistant operates. They have to be able to select them from the outset. They have to be able to modify them. They have to be able to review them, including if it is used by the digital assistant, their profile, their customer profile. Consumers must be able to either stop the conclusion of a contract by objecting to it, for example, by having the possibility of simply pressing a stop button, or must in fact be able to set the digital assistant such that for certain transactions, prior approval is always required. So whereas the function to object is a temporary, brief period of time during which the consumer must object, otherwise the digital assistant will proceed, the confirmation model requires an active step by a consumer to approve the transaction. We also envisage that for some transactions which are automated, the consumer may not wish to be involved any further. They may wish to be executed automatically. For example, if the consumer has instructed a digital assistant to arrange transport to the airport, they just want this to come as quickly as possible and not be lumbered with approving or objecting or whatever else. A consumer must be able to deactivate the digital assistant temporarily or permanently, very important. And we deal with the contractual implications of this for the contract for the supply of the digital assistant in the relevant chapter. So that is something that my colleague Mari-Jill Sørensen will talk about in a fortnight's time. Similarly, we envisage, as I've already indicated, that the disclosure of the use of a digital assistant is in fact a functionality built into the digital assistant and therefore is not something that the consumer or a business has to actively disclose. It will be done by the digital assistant through an appropriate protocol in the design of the digital assistant. Finally, we make it clear that consumers using the digital assistant, and therefore the structure, the user interface of the digital assistant must be designed in such a way that there won't be any manipulation. Because there is a real danger, of course, that consumers might be manipulated in adopting certain settings, in following certain processes when they use a digital assistant, and that will steer the operation of the digital assistant in a particular way. And we think this is something that must be controlled. And finally, we have a fairly loose provision that requires some degree of documentation of decision making. And we do appreciate that this is partly aspirational because of the known challenges about having full documentation of decision making. But we also know that there is already a possibility to have some indicator of the sources that a digital assistant might have considered. So there is a possibility to have at least some idea of how the decision-making process operated. And therefore, that needs to be recordable and accessible to a consumer in order for the consumer to refer back to it in case there's a need to challenge a legally concluded contract on the basis, for example, that this was done in a way that the consumer could not envisage. That is dealt with, of course, in the chapter on algorithmic contracts. I know I've already spoken a bit longer than I should have done, so I will stop here. But of course, I'm sure there'll be plenty of questions. I look forward to the discussion in a short while. Thank you very much.
Thank you very much for this very clear presentation of the framework, the underlying principles, explicit or implicit, and of the design requirements. I think that gives us a good understanding. And with that, we are certainly ready not only to follow the next speakers, but also to make one's own reflection and be ready for the next webinar, if I may say so. But first, we will now continue with some reflections on the ELISE model rules by someone who was not a drafter and therefore has maybe a critical eye, we will see. And this is Professor Zheng Tong. She specializes in private international law and global governance. She's a professor at Wuhan University and deputy director of the Institute of International Law. Before that, she was a professor at Newcastle University in England. And she's the editor-in-chief of the Chinese Journal of Transnational Law, an arbitrator and mediator. She received a few national research awards, and her work on consumer contract has been even cited by the Canadian Supreme Court. So we are really thrilled now to listen to what you have to say, Sophia, and I hand over to you. Thank you very much.
Thank you, Pascal. It's my pleasure to share my reflection in this webinar. In my view, this model rules is a pioneering attempt to regulate the use of algorithmic system in consumer transactions. It provides a forward-looking framework, blending the law, technology, and consumer protection. It may also have international influence, a soft law, and assist harmonization in an indirect way. And compared to ancestral model law, the ELI model rules provides a better protection to consumers. This model rules has many contributions, but in my view, three notable features stand out. The first is the consumer-centric approach. It is evident throughout the text. Consumers must have control over DA. For example, the model rules mandate functionalities such as the ability to set and modify parameters to prevent automatic conclusion of contracts and to deactivate the DA at any times by consumers. These features ensures that consumers are not merely passive users, but are informed controllers in the contracting process. Moreover, the rules also emphasizes disclosure and transparency to protect consumers' meaningful oversight. And secondly, the model rules distribute liability among suppliers, businesses, and consumers in a structured manner. Suppliers bear responsibility for defective DAs, ensuring that developers should prioritize safety and responsibility in design. Businesses are bound by their DA's action unless their contract terms exempt them this liability. If those actions are so unexpected that a reasonable person could conclude there has been a serious failure. So this is a very high threshold, but it can protect businesses from onerous burden. Consumers are required to monitor their DAs, and they can also contest unfair outcomes under Article 22.2. So this framework aims to foster trust in automated contracting system and prevent any one party from bearing disproportionate risk. So that is really good. And the third is the combination of design with legal remedies. There is ex-ante design requirements that compels developers to design responsible AI and to reduce the likelihood of harm. And there's also ex-post legal mechanisms that can provide a redress if failures occur. So in my knowledge, this is the first document that adopt these dual approaches in the contracting automation and the contract process, and that is really an innovation. However, I also noticed there are some critical matters that is very interesting and may require further discussion. The first is these model rules reject the argument that AI may act as legal agent and treat digital assistants as tools. The direct result is the legal consequence of using digital assistants attribute to human users, like consumers and businesses. This result simplifies liability and provides certainty, so that is good. And it can also help avoid the difficulty to ascertain AI personality and AI consent, so that is convenient. But it may also provide inadequate resolution because the digital assistants or AI may grow more and more autonomous. And then when we really treat AI as tools, the rules may not be enough. And AI, especially in the future, the deep learning AI may change its own algorithm to act out of everyone's expectation. Of course, this can be treated like suppliers did not provide sufficient information for the adaptive capacity of AI and may hold suppliers liable. However, this may be unrealistic for the suppliers to predict what may happen and may eventually harms the development of AI in the future. So that is something I think need to take into consideration. And secondly, the consumer-centric approach only works very well if the disclosure and the functionality to modify could work in practice. In terms of disclosure, there is legitimate concern over whether consumers can meaningfully engage with very complex information that has been disclosed by the supplier. And default settings, algorithmic parameters, and adaptive behaviors may not be properly understood by consumers, even if they are disclosed in plain language. And the assumption that information disclosure leads to informed consumer decision is not always true in practice. Furthermore, the model rules put weight on consumer vigilance, assuming consumers will and should regularly monitor and control the DA. But in reality, many consumers just set and forget. Modification takes time and effort and easily ignored by consumers in practice. So reliance on vigilance places burden on consumers. And the third concern is the reasonable expectation exception to contractual liability. And consumers can reject contract if digital assistant act unpredictably, and it is out of reasonable expectation of consumers. Although reasonable expectation is tested by objective standard, but what is reasonable for consumer to expect is quite difficult to assess. And also, what is reasonable for a self-adapting algorithm to act may be different from other tools. And furthermore, it is also unclear whether the reasonable expectation of businesses in this case also matters. Because if only consumers' expectation matters, which cannot be predicted by business, and business may consider the AI of consumers' functions quite normal, there may be insufficient protection for the other party. I also have some doubt on the rule prohibiting manipulation, especially on its enforcement. For example, how to define manipulation and how to assess manipulation. Price discrimination, for example, that increase price in real time based on users' browsing history. Is this a manipulation or not? How can consumers be aware of this manipulation if it really happens? Because in most cases, consumers are not aware of that. And they may aware maybe many times a long time after the contract is finally concluded and see the news report showing this is price discrimination. So manipulative digital assistant may cause systematic harm, but it's very difficult for individual consumers to detect. It may be more suitable for regulation or public enforcement to tackle this matter than relying on private litigation in individual contracts. So in general, I still believe that ELI model rules represents an important contribution to the law on algorithmic contracting with very strong protection for consumers and a fair distribution of risk. It has many innovative perspectives, but the success depends on how well they address the practical and interpretive challenges and how it is going to be adapted to advancing AI. So we may also need to consider whether transparency and functionality to modify could be enough to protect consumers, or we should just ban some harmful features of AI outright. So thank you very much, and that is my reflection.
Thank you very much, Professor Tang, for these very insightful comments, positive and more critical. And we will certainly have the opportunity to come back on many of these points in the Q&A part of this webinar. But before doing so, let's turn to our third and last panelist for today, Simona Stajkova van Bommel. She's an EU official who represented the EU in the negotiations on the model law on automated contracting at UNCITRAL, as presented by Christian Trick-Flessner before. She's currently leading the European Commission team dealing with digitalization of contract law, including automated contracting at EU level. During her work for the European Commission in the last 18 years, Simona worked on EU policies in the fields of contract law, free movement of services and capital, rule of law, and consumer protection. Now, today, she will bring to us the reflection on the ELI's model rules from the European Commission's perspective regarding the topic, and potentially also her own, I don't know, but at least here she is as a representative of the EU Commission. So thank you very much, Simona, for being with us, and I hand over to you.
Thank you so much, Professor Pichonat, and thanks to the European Law Institute for the opportunity to join this discussion. I would like to congratulate the European Law Institute on this important work and deliverable, and as well as all the rapporteurs and all people who were involved in the development of this major project. The European Commission has been following it for years. There were also preceding phases to the project, so we have seen how it has evolved over the years and indeed turned into an ambitious deliverable, which is an important and valuable contribution to the thinking on automated contracting at the international as well as at the European level. And I would like to note several areas where indeed it adds new elements to what has been developed already. It has been touched upon already in the discussion today. But we have the model law on automated contracting developed at international level by UNCITRAL, which focuses on the algorithmic contract, so to say. And here, the model rules of the European Law Institute go beyond the scope they build on it, but they also expand into additional areas, clearly the consumer protection dimension, but also other important aspects such as the contract for the supply of the digital assistant or an automated system more generally, as well as the product design requirements. So in a way, it has a rather broad scope and deals with a wide range of relevant issues for automated contracting. And here I would like to also note one novelty in the rules, which is very interesting and valuable in terms of approach, and it is this integrative use of contract law rules together with product design rules, which we see also in the structure of the model rules. Bringing these two different areas together is an interesting and probably also very helpful approach in view of the practical developments, because in practice, these two areas may be inextricably interlinked. Because if we look at the market developments, at the market use of the digital assistant, then the product design rules may indeed have a big influence on the contractual life cycle and the contractual actions that a tool will then perform for a consumer, on behalf of a consumer. And here I would like to note one important practical aspect, and this is the control. Control of the actions of the system and control of the contracts at the end of the day that it will conclude on behalf of a consumer. So a lot may actually depend on the design phase, where the design could enable the consumer, let's say, to set specifically the parameters for a contract, with whom, what type of traders they would like to contract with, within what price ranges, what type of products are they looking for, and where would they like to purchase them, are there geographical limits, let's say, but also the possibility to deactivate such a system, and maybe also object to unintended actions and unintended contracts that it may conclude. And here I would like to zoom in on the practical side. At the EU level, we are currently also looking into the market developments and the practical developments in the area of automated contracting. And on the one hand, we think there are clear benefits from the use of automated systems by consumers. They can help consumers make better choices in terms of, let's say, saving costs, saving search costs, finding better offers, maybe finding also better conditions for a contract they want to conclude. At the same time, however, there are risks. And one of the big risks for consumers is the risk of unintended actions, unexpected, but in particular, unintended actions. And here we have some data that suggests that 15% of consumers who use the virtual assistant in their purchases ended up paying for products or services they did not want to buy. And this is a serious concern. This is an issue which could actually hold back consumers from taking up automated digital assistants in the first place, because this is a risk that in practice may entail high costs. Now, we also know that a lot of consumers are shopping online. 3 in 4 consumers are potential online shoppers. And we know that consumers are increasingly exposed also to online practices that may be damaging as a result of the increased use of AI. However, what we don't know at this stage is what is the exact nature and scale of the problems that consumers may face as a result of using digital assistants in automated contracting. So this is an area which we are currently exploring. We are collecting evidence on this, and the evidence of the real market problems, their nature, their scope, and how they affect consumers is actually essential for our work and for the decisions on whether there is a need for some kind of an intervention to address these damaging practices for consumers. So at this stage, we are collecting evidence in different ways, and I would just say a few words on the different work strands that are ongoing. Since this is a project, the early model rules are a project with a focus on consumer law. A clearly highly relevant initiative at the EU level is the work on the Digital Fairness Act. So this is a big initiative which is ongoing in the consumer field. We are currently collecting evidence that will feed into an impact assessment under this initiative, and it deals with a wide range of issues that consumers face in the digital economy. Automated contracting could be one of these issues. It has been recognized indeed as a relevant development. In the preceding analysis we had on the fitness check of consumer law for digital fairness. So this fitness check recognized that automated contracting is an emerging practice, that consumers are engaging in it, and indeed they may face new issues such as limited control on their purchases. It is also recognized that the current consumer law directives may not be fully adapted to these new developments, but it remains to be seen how these developments will indeed affect consumers and respectively also the application of consumer law. So all of this will feed into the analysis under the Digital Fairness Act. And any kind of potential inclusion of automated contracting as an issue will depend indeed on the findings on the problems and whether indeed there are big problems that consumers are facing in this specific field. But now a few words also on the broader work on automated contracting, because the issues we are discussing today are highly relevant for consumers, but could also be relevant for businesses that engage in automated contracting. issues like attribution of actions, validity of contracts, how to deal with unexpected actions of automated systems, are indeed all issues relevant also for business users. So we have also work ongoing in a broader sense beyond specific rules of consumer law. First, the EU and its member states participated actively in the development of the UNCITRAL model law on automated contracting at the international level. Now, at the EU level, an important development is the AI Continent Action Plan, which announces a forthcoming Apply AI strategy, which it refers also and will include also automated contracting as one of the sectors that it will be looking at. It will have also a sectorial approach focusing on strategic sectors for the development of AI. And thirdly, zooming in truly on the legal side of automated contracting, we have another big initiative ongoing, and this is the High-Level Forum on Justice for Growth. This is a high-level dialogue that was launched by Commissioner McGrath, the Commissioner for Justice and Consumers. And the purpose of this high-level discussion with member states and with stakeholders is to discuss what are the needs and priorities to focus on in the area of civil company law, as well as the digitalization of justice. The topic of automated contracting will be part of the third discussion, the third meeting of this high-level forum, which will take place in the autumn, and it should conclude its work by the end of the year. So here I would like to, since the time has advanced, also conclude by saying that this work of the European Law Institute is a very important, valuable, and timely contribution, and that it will feed in also into the work strands and the reflections we have at the EU level. It contributes a very solid legal analysis throughout the different phases we saw of the development of this project, but now also important ideas as regards possible solutions. So I would like to thank all involved very much again, and I look forward to the discussion.
Thank you very much, Simona Stalkova van Bommel, for this very precise presentation of, the larger framework also in which this project may get into, and the recent works and work to come of the European Union in that field, because indeed a lot is moving right now, even if the European Law Institute participated to the public consultation on the definition of artificial intelligence recently, trying to understand what are the characteristic features, and in a way a digital assistant might be linked to AI or not, and that might have, as Christian Trick-Flessner has expressed, some consequences on the rule to apply, depending or not on the degree of autonomy, or as Professor Tang also mentioned, AI becoming more and more autonomous, or even creating itself new digital assistant. And so we might get into a very difficult situation, and that's why it's really important, I think, that this not only Digital Fairness Act, but that this high-level forum on justice for growth has really takes place and takes that also into account. So thank you very much. We get now in the second part of our roundtable, if I may say so, with questions and answers. And so you can use the Q&A button, of course, to ask us any questions. But in the meantime, I would suggest that maybe Christian Trick-Flessner could react to some of the points mentioned by Sophia Tang. In particular, the points she said here, why did you choose this and not that function? And maybe you could also explain a bit more what was behind, or maybe why you didn't choose or did, the further steps. So I hand over to you, Christian.
Yes, thank you very much. Thank you, Professor Tang, for your comments, and they're all well taken. They're all excellent remarks, and I should say, maybe as a more general comment, first of all, of course, we are hoping that what we have put on the table will provoke debate. Even though we think these are pretty robust and coherent rules, there's always room for fine-tuning, for improvement, for just thinking again. So I'm very grateful for your opening gambit here for us to just think a little bit further. And who knows, maybe in 5 years' time we'll have an update on these rules. The time may come for this. I'll just say a few words on the comments you did raise. Yes, you're right. We deliberately didn't go down the route of exploring the position of digital assistants as agents. There's a number of reasons for this. First of all, even in the tech landscape, there's been a shift away from this idea of AI replacing people and AI kind of subsuming things. It's more and more a shift towards actually recognizing that AI, at least where it currently is at, and the quality of the technology that it currently has, is more a case of having an advanced tool for people to work with. So this human tool interaction is much more prevalent now in the discussion. That may change, of course, if the technology becomes more advanced, more robust, and more reliable. And if there were to be a decision to treat an AI system as something more than just a tool, I think that would have to be done in a much wider context than just this particular application. Because ultimately, of course, we are talking about an application that is based on algorithms that may or may not be AI in the sense that we understand it now. This could be an entirely deterministic system, for example. We're being very sort of inclusive in our conception of a DA, but of course we do recognize that what we really are thinking about are those ones that can adapt, that can react to different data inputs, that are more agile than your deterministic algorithm. Now, we were also very conscious about the risk of anthropomorphizing any kind of AI-based system. And that's partly why we decided to step away from the idea of agents, because the whole concept of agency in law, at least, not in philosophy, there's a whole different debate to be had there. The concept of agency in law is kind of based on natural legal persons. And we were just cautious that there is a danger of exaggerating the significance of AI, if you can if you can say this, by treating them as anything but a tool. That said, some of the challenges that arise with the use of AI agents, of course, do resemble the kinds of challenges we have with proper agents, if you like. For example, exceeding authorities. If I preset parameters and the digital assistant goes off and does something else, it's a question of he's exceeded, oh God, I've done it. It has exceeded its authority. And of course, that is something that could be tackled perhaps by some kind of analogous approach. But we were concerned that simply to equate a digital assistant with a legal agent would be going too far in a sense. That was one point. Now, the consumer in control, the consumer-centric approach is obviously key to what we've done. And I take the point that you've made that some of the provisions we have to give consumers the control, to provide them with information, have their own challenges. And we all know about the limits of information and the dangers associated with that. And we also do know that some consumers really might just want, depending on the potential of the DA, might just want to let it run in the background and not care. They might just want to forget about it. And that's fine. But what we wanted to make sure is that there are still the features built into the DA that would allow a consumer who wants to step in to do so. In other words, for this thing not to become completely uncontrollable by design. There's, of course, always the risk that the technology might do weird things. We've seen this everywhere in all kinds of technologies, so that danger can't be ruled out completely. But we wanted to ensure there is control. If consumers don't want to use it, in fact, we envisage that consumers can effectively choose not to use it. That is fine. That's part of consumer autonomy. And yes, the reasonable expectation standard in Article 22, which of course Marie will probably talk about more in a fortnight's time, that is of course a tricky one. We did think about the right way of expressing this for a long time, and we decided to settle on this test because it is familiar from consumer law. Now, that may have been not an ideal choice, but we felt it was a sufficiently malleable concept for us to deploy it here. Maybe that is one instance where we have to rethink the formulation. Once we've tried this rule out in practice, maybe a slightly different formulation might work better. But this is the kind of effectively the compromise we arrived at. And of course, manipulation is a big challenge, and that's something really where we just wanted to put down a marker saying, ideally, these things shouldn't manipulate, and consumers should not be manipulated, and these things should not be manipulated. But I appreciate how this plays out in practice is going to be a big challenge. We can't rule out the need for ex post enforcement. Of course we can't, but then you always have to deal with unexpected events once things have gone wrong. But we try to just get ahead of the curve by trying to channel these things a little bit more than they currently would be channeled, by just letting people put things on the market with a basic conformity requirement, which may or may not help.
Thank you. That really explains a lot of backgrounds. I just want to clarify. I feel this ELI model rules is really good, but it's not interesting to just talking about good things. So it would be more interesting to generate debate and discussion.
Yeah, of course, and you are highly welcome, of course, because these are points indeed that were discussed, as I said, also within the ELI Council, and I can remember some early drafts on the notion of agent or not, where the reporters had presented various avenues trying to find out the best solution, and for instance, the issue of agency and agent as a matter of contract law, of course, is also tricky because the applicable rules might vary a lot from one legal system to the other. So there's, of course, a whole lot of implication by these choices. But for the time being, personally, if I may just express my personal view here, I think also that considering a digital assistant as smart tools is probably a safe way, because there are still, people in charge. And in a way, even if they become more autonomous, as long as they are not independent with their own assets, the whole issue, in fact, of treating them as quasi e-persons might be tricky, because if they are liable, or if you consider that they go beyond the rights or the instructions they got, there should be consequences, and these consequences might be of financial perspective, and for that you need some e-wallets, for instance, or you need some assets. But maybe we will come back to that. I see that we have a couple of questions online, and of course you are still welcome to ask further questions. One question is about clarifying the position on treating digital assistant as object of contractual and or in rem legal construction, because it's one thing indeed to say it's a tool, but if I understand correctly, the question is really, is this a tool that is considered to be ownership of one party? Does it change something whether we discuss the in rem perspective, or whether we should look at it only on the level of contractual relationship? Of course, my pandectist approach would have an answer to that, but I hand over to you, Christian.
In the model rules, we've basically equated a digital assistant with an app, in short. So we're treating it as a software, as a program, as a form of digital content. And that's partly because that allows us to tap into general rules on the supply of digital content that exist, for example, in EU law, in the Digital Content and Digital Services Directive. They exist in the UK, in the Consumer Rights Act 2015, and elsewhere around the world. So we felt that this was the best way of looking at this. Because in a sense, AI deep down, even though it's pretty amazing a lot of the time, is ultimately another type of algorithm. It is another type of program. And for that reason, we basically equate it and look at it in the same way as we would look at any other program, any other form of software, and therefore questions around licenses and intellectual property ownership are pretty much the same as you would apply to any other software program. That's the way we approached it. Whether in the future this analysis may no longer hold, I cannot say, but for now, I think this seems to be the only sensible analysis.
I agree. Thank you. And also the question to determine whether it's owned or whether, it's only a use of something, it's not central here in terms of AI contracting, right? It's on a different level, so we don't care so much, as well as we do not care whether it's a product within the new EU directive on product liability. It is certainly but that's not the question here, and so that could be left open. I see a second question, which states the following, that digitalization requires a new approach to consumer protection, and that person would like to clarify whether it is possible to apply these rules to protect the rights of consumers of financial services, because of course algorithmic contracting are used also in financial services, and also by consumers, not only B2B contracts. So I don't know whether, Christian, you want to react on that too.
Well, we didn't deliberately exclude financial services from the scope of our model rules, but there are model rules, and of course, if anybody were to adopt those model rules, whether it's the European Union legislator or any national legislator around the world, they may feel differently about the kinds of contracts that should be within the scope of any legislation based on our model rules. Of course, we hope lots of countries will take them up and will take an interest, but we'll have to wait and see. Of course, financial services bring with them the added complications. They're heavily regulated. There are lots of extra requirements. So some of those may lend themselves more readily than others to automation, especially with the wider concerns around money laundering and everything else that's going on in the background. So in terms of the narrow consumer making a decision to conclude a financial services contract, the digital assistant could work for that, and the rules that we have could apply to that. But there will be other rules, more significant rules in the background that are not superseded by what we do. So we don't at all want to displace any regulatory requirements regarding specific contract types that a consumer may conclude. And that's made clear already by our guiding principle that says consumer law continues to apply. And by extension, you could say any other relevant regulation for the particular contract type in question would also continue to apply, because we shouldn't see this as a way of evading the law and the legal requirements that exist. This is very much a tool to support consumers in making life a little bit easier, not in kind of evading the law.
Thank you very much. Now, if I would be the devil's advocate, I could say that this field, of course, of financial services is maybe the field where a protection of consumers, including for algorithmic contracting, is the most important. And so it might, at first sight, look a bit strange to leave that out when it's so central, and where we probably can expect the European Union to regulate, or at least to look into that into more details. But if I understand your answer, and I will open, then you may add something, but if I understand your answer, the idea is not to say we don't want to regulate that, but it's so heavy with further duties and so on that in a way that would have not brought up a match. But maybe the guiding principles. Don't you think that the guiding principles might be also very good guiding principles for their financial services, even if it's carved out in the black letter that we got in front of us? In fact, it would fit. Am I wrong by saying that?
No, absolutely. The guiding principles can, of course, be deployed much more widely. And like I say, you can, and the rules that we have would support this, can use the digital assistant for any contracting type that the consumer may wish to conclude. But the point I was going to make is that we are effectively, yes, we are saying a consumer can do this if they wanted to. That's fine. A digital assistant may be designed for this very purpose. That's fine. We still think the different requirements that we have would be relevant even for those kinds of contracts, insurance contracts, other financial services contracts, credit agreements, you name it. But we are very conscious that there's a lot more going on with some of these contracts and a lot more hurdles that need to be gone through. And we shouldn't see a digital assistant as a shortcut for avoiding those rules. That was the point I really wanted to make. So yes, of course, we don't say there's a limit to the kinds of contracts for which a consumer might wish to use a digital assistant. Those limits may instead be set by any national law implementing our model rules or adopting our model rules. It may be set by the very nature of the regulatory framework that's in the background, because that might make it less or more appropriate to use a digital assistant, to use automation specifically.
Thank you very much. Since I do not see further questions, I may add a further question myself, and that might be to Professor Tang, because here we have ELI model rules that are obviously primarily thought for consumer contract, first of all, but also for the EU market. But we hear often also with the EU legislation that there is this so-called Brussels effect, and that maybe what has been thought through in Europe might impact also other parts of the world. So Simona Stajkova-Van Bommel already mentioned the impact, or at least some inspiration that these model rules had on UNCITRAL work. Would you see some potential impact of these rules in China, for instance, and to what extent, or whether the ecosystem that is already in place support such an approach, or on the contrary, would present some challenges, and in that case, which type of challenges?
I would say in general, China is quite developed in terms of AI development and those technology used in practice. But China doesn't have relevant rules in relation to regulating automated contracting in consumer context. So this is currently a legal gap. I'm considering it is worth to explore some rules already made in other countries and the international organization. Recently, UNCITRAL has passed that model law, and I actually participated in those sessions as an observer. And I realized some Chinese organizations also sent observers in UNCITRAL. And then after the model law is adopted, there are a few events in China discussing the model law and its potential effect in China and whether we would like to adopt it at all. But we all understand that China can be quite slow in doing that, unless there are really urgent requirement to regulate automated consumer contracting. And I can see that the ELI model rules may have the similar situation. I see that ELI model law, it does not have a geographical limitation. That means it doesn't say it can only limit it to be used in EU, and these rules actually are very neutral. It doesn't have very strong EU perspectives there, so it actually can be transported and transplanted in other countries. I can't see any technical prevention there as well. And I also, from my perspective, China is quite conservative in some way. So it is quite difficult for China to recognize AI as agent as well, because that brings a lot of legal challenges. So treating AI as tools is more likely, and in the same time will impose more liability to the suppliers. So that is designers. But because China want to advance AI, so China may not like to give them too much responsibility at this stage. So if they want to adopt this rule, that probably is for the future.
Thank you very much. That's very clear and very useful as well. And indeed, one implicit general rule or principle mentioned by Christian Twig Flessner is is on the risk allocation between supplier businesses and consumers. And here, of course, there are some obvious discussions which are again implicit, because if you say it's a tool, then you have an implicit allocation of risk to some extent. And this is a balancing between innovation and protection. And that might be where the biggest policy issues are getting at. And maybe since we are speaking about policy issues, I'm wondering, Simona Stajkova-Van, how the EU sees that. I mean, in this triangle between supplier, business party to the consumer contract concluded by an AI or digital assistant, whether this risk allocation between all three, putting, protecting consumers, putting some liability also on the business person using or not accepting, because the idea is you have to accept apart from a couple of situations, and therefore this allocation of risk. Do you think that maybe you cannot speak for the EU, but at least for you in your personal capacity, do you think that's the right balance taken?
Thank you so much for this very difficult question. Again, in my personal capacity, I can comment on this because we do not have a position on this point yet, but I can share with you that also in the discussions on the model law on automated contracting, this question of risk allocation was a very difficult point in the discussion. And respectively, we ended up also with an optional provision on unexpected actions, which is put in square brackets in the model law. So in a way, this is a consequence of the complex debate we had, at the core of it being the question of risk allocation, and in particular, who should bear the risk for the unexpected action? How should we allocate this risk? And indeed, in this discussion, it is important to consider all the players involved. And the model law at the UNCITRAL level looked only at two parties. It looked at two players, so to say, the contracting parties, or the parties that may enter into a contract. While the model rules of the European Law Institute look at three parties. The third very important party is the provider of this automated system or digital assistant in this case, which in many cases will be a third party. And this, in fact, I think it is important also to take account of the market developments. How are these digital assistants put into operation? How can you access them? And often they are actually provided by third parties, by third-party developers. You could access them maybe on a platform, or it could also be provided by the other contracting party, let's say an airline company that sells tickets that has an inbuilt automated system for dynamic pricing. So it could be also a proprietary system of one of the parties. But we have a variety of use cases, and in many of these cases, it may be a third party. So we have three players, and we need to find a way how to allocate the risk between these three players. And what is the appropriate balance is a very difficult question. I see that you have proposed the solution, which is indeed one possibility, which raises questions, as we heard in the discussion today, because thinking of the other party, then maybe they will bear too much risk, which they cannot assess, and therefore may be held back from deploying such automated systems in the market. So it is a very important question. At the EU level, the way we approach these kind of questions is starting always from the problem. So we need to try to understand, we always aim to understand as far as we can, the actual market developments, the market practices, who is affected, to what extent, in what way, and to estimate also the costs and benefits of possible solutions. So all of this potentially could be part of an impact assessment or not. It depends on whether we do identify a problem, and then based on this problem, we will have to think of the solutions and then balance it, the right balance in view of the costs and benefits for the different parties. But at this stage, I cannot unfortunately comment on the best solution because it is a very difficult question. And in different scenarios, business to business or business to consumer, we may also have different solutions. So it remains to be seen. But thank you for the question.
Thank you very much also for the answer. I think you put exactly the right focus, and I would add something, because in the we might come back on the next webinar with that, but in Article 20, Principle 21 on unexpected results, or it's a perspective of the consumer. Right. And so what for the consumer will be objectively unexpected with, of course, objectives. So it's not just the perspective of the consumer, but it's from the angle of the consumer. Now, the principles do not close the door, of course, of assessing the whole ecosystem, where you will have also digital assistant on the side of the business partner. And that might happen more often than we think right now, of course, so that we will have a kind of digital assistant against or with digital assistant on both sides. Therefore, the question might be how to take into account these two perspectives in the allocation of unexpected consequences of the conclusion of the contract, especially if it might be also difficult to determine on which side or on which digital assistant the unexpected result has to be retrieved, which digital assistant, if any, has caused the unexpected result. And so I don't know whether this might also be something to take into account. Simona, please.
Thank you so much. If I may just come back on this point of unexpected actions, I think it is by now probably generally widely at least acknowledged that this is a very difficult matter of finding the right balance, how to allocate the risk and the consequences of unexpected actions. But maybe there is also a lot of potential in thinking how to prevent unexpected actions. And here, I think that the model rules put forward very interesting solutions, just shifting the focus to the pre-contractual stage and the early stage of choosing a digital assistant in the first place. Because if this digital assistant indeed has the functionalities where you can better control the actions and you can potentially object to unintended actions, that you will not end up with these unwanted, undesirable results at the end, once the contract is concluded and you bear the consequences. So maybe this could be an interesting avenue to indeed consider and explore in the thinking how to deal with unexpected actions and how to lower the risks and respectively the costs for all parties involved. Because just preventing them in the first place may solve the problem for all parties involved in a more cost-effective way.
Thank you very much. You are perfectly right. And these design issues are so central. And that makes the peculiarity, if I may say so, of these model rules drafted by the ELI. Christian, please.
Thank you. There's a few points that now I wanted to emphasize. First of all, on the unexpected contracts provision, Article 22, paragraph 2, it is that deals mainly with that. Now, you've got to bear in mind, in the overall framework of our model rules, that is the final step, the long stop, as it were, the safety net for consumers. Because as Simona has rightly said, we have the ex-ante controls envisaged through the design requirements. And in fact, when we had the interim report, those of you who read the interim report may recall this, we had no indication and no reference to any kind of rules on what we do after such contracts have been formed, other than to say, if a digital assistant acts beyond the parameters that have been set by a consumer, it's not in conformity, everything falls on the supplier of the digital assistant. That's now being more nuanced by also having this possibility of just setting the contract aside. But note that, of course, that leaves the businesses, the third-party businesses exposed. And that's why we have Chapter 5, Article 25, that deals specifically with the protection of our third-party businesses. And this is where the balance of, or the distribution of risk comes in, because we didn't want to leave the business entirely exposed. We did want to allow them to have some kind of recourse against the supply of the digital assistant. But you're right, this whole question of unexpected contracts is very much in everybody's mind. We've all seen the initial reports of some rudimentary digital assistants. There was a wonderful story, I think, in the Washington Post a few weeks ago, where the digital assistant was asked to just, look at the price of some eggs, which of course are already a luxury item in some countries at the moment. And not only did the digital assistant find the price, but also went ahead and proceeded to place an order for a dozen eggs for a fairly high amount of money, I believe something in the region of 30 euros or the equivalent thereof. So we can see how these things can in reality cause these problems. But what we've tried to do with our rule and the combination with the design requirements is to ensure that the risk of these unexpected contracts can be both managed by a consumer and give the consumer some kind of fallback if, despite everything, things have gone wrong. And this is something that only emerged as we worked through the principles, as we developed them, as we had consultation rounds with ELI bodies. It became clear to us we needed to do something, and then finding the right way of presenting this was, of course, difficult. And I think the compromise we have is probably okay, but there's obviously room for debate around this, and that's great. Let me just make one other point that came to my mind as well. But, and this is when I was listening to Simone, and I appreciate European lawmaking acts in response to problems. And that may be obviously the case in many other contexts as well. But what we have here is one of those rare instances where we have a digital development, a technological development that is on the horizon that we can see coming, where we know there is a risk of problems, and where we could act now to actually have something in place that channels this development a bit better and that encourages those developing applications to be more mindful of the kinds of things they need to address before they put applications onto the market. This is often not possible because by the time things are on the market, it's already too late. And we have seen this in so many instances in the digital world where the problems were identified too late. Now, we may be completely off the mark, and that is a well-known risk when you try and regulate technology or legislate for technological applications earlier in the day. But I think we have a very good chance to put something into place that could actually make the market work better from the start. And the problems that you're looking for might actually be fewer and far between than there would normally be. And if you wait for problems to arise, it might already be too late for consumers.
Okay, we'll see whether the EU has an ear for that suggestion. And even if one says we will act immediately, the legislative process is such that this takes months and years, so that what is immediate takes, in any case, many decades, at least many months and years. Of course, I would have a lot of questions, but I think I do not want to generate just questions for the purpose of generating questions. Apart from maybe one question, Christian, if I may, and that's maybe we will come back next webinar on the 24th on that. I don't know, but you mentioned the stop of the conclusion of the contract, which is one possibility, but also try to, I mean, there are different settings. One is to consent, one is to stop afterwards. Now, dogmatically, I was just wondering how you understand that. Are they just two different features, but basically contractually, the contract is not concluded before the consumer acts? Or do you see a huge difference in the second option when you stop the conclusion? In fact, the contract was concluded and it's a kind of cooling off period and then might be treated alike, but then with consequences in the organization with the businesses, because of course, if there's a valid contract that has been gone through, then of course it's more difficult. So maybe just to make the distinction between two, or whether it's just a technical contract.
No, it's absolutely right. And we actually changed the wording of that particular design requirement quite late in the day, because the very concern that you just raised was expressed by a member of the council, and we did think about it and decided there has to be some kind of acknowledgement of that. And in fact, if we look at the wording we've now adopted, and this is where we have unfortunately or fortunately borrowed from EU law, we are now not talking about the conclusion of the contract, but the placing of the order. Now, the reason we've done this is twofold. First of all, we expect these digital assistants to work primarily or exclusively in an online setting, at least initially. In the future, who knows what will happen, but this is the kind of paradigm we worked with. And therefore, we are looking at a typically online concluded contract. Now, we did notice that the EU's e-commerce directive, for example, uses the term placing the order. And indeed, placing of the order is also used elsewhere, and a lot hinges around that. And therefore, we felt maybe to clarify this point, it's concerned that, is this a withdrawal right, or is this a pre-contract conclusion right? We wanted to clarify this by saying, well, if we prevent the placing of an order, there cannot be a contract anyway. At least a contract for the goods and services. There may be other background contracts, of course, that we know about. We do acknowledge that there are rights of withdrawal. And of course, they continue to apply after the contract has been concluded. But we wanted something before this point arrives, because, of course, some contracts do not attract a right of withdrawal. And withdrawing from a contract is costly for both consumer and business, because imagine the consumer, the business has already dispatched goods to the consumer. They're in the postal system. They've paid their courier. They now have to be returned, restocked. Quite often, goods are not restocked. They're simply junked. This is a loss to the business. So in order to recognize again the distribution of risk between both affected parties, we felt a chance for the consumer to just say no before it gets to the point where the consumer's actions have been completed is the crucial thing. And that's what we've done in the way we phrased the design requirements. So it's very much to avoid the contract coming into existence in the first place. If for whatever reason we have a contract and it turns out to be of such a kind that it wouldn't have been reasonably expected, of course, then we have Article 22 to help us out in the long run. Provided, of course, the consumer doesn't already have the ability to withdraw from the contract anyway, because they have a right of withdrawal for an online contract.
Yeah.
And just one other point before we finish,
please,
Pascal,
please,
because I forgot to respond to this point earlier. You said, well, what if the business also uses the digital assistant? Of course, businesses already use them all the time. I think it's Elisa Mick who's made the point repeatedly. Amazon's website, for instance, to mention one particular online retailer, is a big digital assistant that the business uses to automate its actions. Because, of course, you don't deal with any human person when you're placing an order on a website. You're dealing with an algorithm already. So there's already a digital assistant used by the business. So in many ways, we are actually going to the situation where we have DAs talking to DAs, the consumer's DA talking to the already existing website. So that situation is already there. It's not something that would be a novelty. And that's why we're thinking a lot of these questions around disclosure and so on can be done through automation, because there are two algorithms who are looking for certain bits of data coming each way that can interact on that basis.
Yeah, thank you very much. Yeah, indeed. I don't see any other requirement for or request for comments by the two other panelists. If that's the case, I would consider that we are getting to an end. And I would suggest that, well, let me first of all thank you very much. I think that this panel has been really interesting. We got a lot of insight. And as a first introduction to these model rules and principles, this is certainly something very useful. So thank you very much to all three of you for sharing with us all your views and understanding of these aspects. Then, of course, I wanted to say, for those who understood from this that there's still a lot to discuss, I'm happy to invite you all for the next discussion we will have. As said a couple of times already, on the 24th of June, we will have a second webinar from 12:30 to 2 p.m. discussing now more specifically some of the two aspects of the two contracts, the suppliers contract, but more importantly, I don't know, but with a specific focus on algorithmic contracts. So what was called a contract 2 in the slide presented by Christian Trygg-Flessner. And so there will be again all this discussion about what about mistake? Does it still exist under these principles? What about, I don't know, further aspects of contract law? So we will come back to that. So I invite you all to register and be with us on the 24th of June. And in the meantime, let me thank again in our names the three panelists. Thank you very much for your presence, for your thoughtful inputs, and enjoy the rest of your day. Thank you very much. Bye-bye.